Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel. Honestly, you don't want to be taking generic legal advice from a YouTube channel or podcast in any event. On with the show. Creativity and Copyright, an interview with authors John L. Geiger and Hoeg Suber. Hello and welcome to a very special episode of Virtual Legality. I'm your host, Richard Hoeg, managing partner of the Hoeg Law business law firm of Northville, Michigan. And on this very special episode, we actually have the authors of a book that was sent to me by my friends at the University of California Press called Creativity and Copyright, Legal Essentials for Screenwriters and Creative Artists, a book that I really enjoyed and is a very quick read. And so I'd like to introduce both John and Howard here. Say hi, and then I'll give your full formal introductions.
Hey, Rick,
Hi.
It's great to be with you.
Yes.
Hey, gentlemen.
This is-
So correct me on any of this. I'm going to read from the back of the book here. I want everybody that's listening to this episode to know exactly who you are. John Geiger is a screenwriter and intellectual property attorney in Los Angeles with 30-plus years of litigation and transactional experience, representing a broad variety of entertainment professionals, including screenwriters, producers, directors, and actors. Howard Suber has taught generations of screenwriters, directors, producers, and film scholars during his more than 50 years at UCLA's celebrated film school. He has also been a consultant and expert witness for Hollywood studios and networks on copyright and creative control matters. Does that all sound right to you, gentlemen?
Yeah.
Sounds true and correct, and I think we'll sign it under penalty of perjury, Rick.
Always good to have a summary, right, of a paragraph of your life's work. By the way, Howard, I have to give a warning here. My wife is a Trojan. I hope we don't have to cut off the discussion right now.
I don't know what that means.
She's a USC.
I know what that means. I know what that means.
Oh, that other school across town.
Yes,
Yeah.
you know, somewhere else in Southern California.
Yeah, I think they even have a film program.
That's what I hear. That's what I hear. I don't know. James Earl Jones talks to me at the beginning of Michigan Wolverines football games, so I hear that he's got some connection with California. But thank you so much for being here. We love to talk about law on Virtual Legality. I know you probably are well aware YouTube is just a font of legal knowledge.
Yeah, yeah. And maybe disinformation as well.
Oh, heaven forfend. Yeah, no, absolutely. But we at Virtual Legality try to have conversations that help people just think about a little bit more about what they're looking at in terms of news. A lot of it's pop culture. A lot of it's what you're talking about here in respect of the film industry and television and pitches and screenplays and scripts.
Yeah, it's funny, Rick. I was going to say,
Yeah.
even before the advent of YouTube, I remember when you would go into bookstores, bricks and mortar bookstores,
Sure.
and in the film and film business sections, those bookshelves had a tsunami of how-to books and books with legal advice for screenwriters. So it doesn't surprise me that as we've moved into the virtual world and the streaming world, that there is a follow-up to that in a tsunami. But the thing that I noted, being a lawyer first and a screenwriter second, at least chronologically, is that many of the works that were out there didn't have legal citations. I had no way as a lawyer of validating whether the advice was good or not,
Sure.
or valid or not. So one of the things when Howard and I started kicking this book around was that I wanted to have something that was verifiable, that when you or your attorney pick this up and we say something of a legal bent, it's annotated. You're able to go to the actual source rather than to having to take our word for it alone.
Oh, I love endnotes, and I was happy to see them.
Yeah. But it's not one of those legal tomes
Nope.
that you fall asleep constantly trying to figure out what they're saying.
It's not a tome at all, which was part of the goal. No one wants to read a long book about law.
Yeah, when I was sent this, I got it, and I think I read it in 2 nights because it's a really quick read. I imagine that was one of your goals, was to make it as approachable as possible.
Yep.
And I tell my clients that's the hardest thing to do is you want to take legalese, you want to make it simplified. That's a real trick, and I think it's really impressive in the book.
Well, thank you so much. We wrote it in 2 nights also, though each night was 6 years long.
I bet.
2 nights and 12 years.
Yeah.
No, that sounds like an undertaking in of itself.
Yeah.
It really was. When we started off on this, we were lunching frequently and talking about law and literature and all things film, and both had the same notion about a book that looked a lot like this. And we thought, this will be the easiest thing in the world. Why don't we just trade email about it? And after a while, we'll just hit print, put a binding on, and we're.
That's the usual way. But...
Of course, that had didn't play out at all. We found that after a year or so of doing that, we had this undifferentiated mass of text. So it really was a function of working our way back and finding what was at the core of this.
Yeah, absolutely. I know you reference in a couple places in the book, I think in the foreword as well as on the back of the book, that Strunk and White and Elements of Style was an inspiration for really having a document, a book that you could just kind of look at and refer to. Was that part of the inspiration for this?
Yeah.
As in the editing process, it certainly became that. As we started working through the topics and deciding what should be in and what should not. The structural, and we're both structuralists, the structure had to be accessible. And really, I find that one of the most accessible guidebooks out there's an evergreen in it, is Strunk and White.
Absolutely. I remember it being assigned to me pretty early on in my career. Is that the kind of thing you see for a potential audience for this kind of book, is having it assigned in various schools and things like that?
From your lips to God's ear.
Sure.
Yeah.
Well, that's a pretty good market for it, I would imagine.
Yeah, well, I know because I taught, even though I'm not licensed to practice law in the state of California, I did have a 40-year period in which I was an expert witness in a lot of film copyright cases. And so students would constantly send me emails when that was fashionable, and or talk to me about problems they had. And so over the years, I began to see sort of fundamental misunderstanding on the part of an awful lot of screenwriters, as well as, of course, directors, producers, etc. And one of the things that always disturbed me was that people were more afraid of what they couldn't do, and were misinformed about what they couldn't do.
Sure.
Then they were aware of what they could do, because copyright is not only a list of don'ts, it's a list of do's. That's why we've got 2 back-to-back chapters. One is called What You Can Steal from Others, and then the next one is What Others Can Steal from You. And we explain that, of course, we're not literally advising people to steal, but what so many creative people think they can't do is just misinformation.
Sure.
Nobody's told them that copyright covers things that are protectable. And in the various lawsuits I've been involved with, often the plaintiff is just naive. They think that because they put together, to take one case, they put together a disaster film involving tornadoes with a love story, that somehow they own the idea of combining a love story with a disaster film.
Sure.
Whereas if you know anything about the huge number of disaster films, you know that virtually every single one of them combines a love story. So nobody owns that idea. And there are many examples of what people think somebody else owns that nobody owns.
Well, that is the paradox. On the one hand, consider everything that you read, hear, see, whether it's in books, newspapers, on the internet, anywhere, to be copyrighted. But on the other hand, much of what folks claim to be copyrighted actually is material that's not protectable by copyright law. And one of the original cores of inspiration for this book was to look not only at federal copyright law, but at the 60 plus years of narrative in the California Circuit Courts about idea theft. It really is the Disney v. Wilder issue of a guy comes into studios and pitches story ideas. Everyone tells him no, and yet a few years later, there's the story on the screen. So that is as much a concern as the pure copyright infringement.
Sure, absolutely. And I think that's a useful service. One of the things I have as a note here as I was reading the book is that I really like the positivity of it. I really like, as Howard mentioned, that Steal Your Stuff chapter has a quote here that says, "You probably didn't steal your story. The world is unbelievably rich, treasure trove of stories that are yours for the taking." And I really like that as a concept of, we lawyers often get called wet blankets for saying no all the time. And truthfully, you get a lot of no because you don't know what's in the shadows. But what can really help out is knowing what you can say yes to.
Right.
Very much so. Very much so. And I think a lot of well-meaning writers unnecessarily censor themselves because there is that concern of wanting to do the right thing and not to be an infringer, when in fact, life experience is free for the taking.
Yeah, and I think that's an important distinction. Absolutely.
One of the patterns I've noticed over was actually 53 years before I retired last year in students at UCLA is there's a pretty general confusion among creative people between plagiarism and copyright. Plagiarism is what you learn in junior high, if not earlier, which is basically a version of the golden rule. If you're going to take not only words, but ideas that you discovered from somebody else, then you're supposed to say where you got it. And in going through educational systems, we've all learned of people who got their knuckles rapped, if not expelled, because they plagiarized. But you can't copyright an idea.
Right.
So all those people who are worried about, gee, I didn't give credit to the idea, lead, in my experience, to a lot of people saying, okay, I got the inspiration from this book that I read, so I have to buy the rights to this book.
Sure.
No, you don't. And besides which, you're a starving young writer. You don't have the kind of money it would take to buy a book. And yet people get really stumped by that, and they say, oh, I guess I better not write this because I can't afford to buy that book. Well, neither an idea, such as tornadoes and love stories together, or as in, I had one case where the expert witness on the other side said the theme of this book is man's inhumanity to man. Well, you just gave the same reaction I had. Where is there a book which could not be described that way?
Sure.
And then he went on to say, and the other theme is to thine own self be true. To which I responded in a statement, where is there a popular book that says to thine own self be false? These are not story ideas. They're not even ideas. They're cliched expressions of some piety, none of which belongs to anybody. And just because you you may have never heard that you should be true to yourself until you read this book or saw this movie. Doesn't mean that somebody owns it.
Absolutely. I think if anything, at some point I'm going to have to make a T-shirt that just says "Ideas are not expressions." That would be an expression, of course, once I did it.
I was going to say, right, with an asterisk, except for here.
That seems like you could make a pretty good meta commentary T-shirt. I'm writing this down. You didn't hear this. No, I think that's a fantastic lesson for people to know, and I think it comes from a place of being well-meaning, right? You say, I read this book, I should have to buy it. It's from people that say I shouldn't be stealing things.
Yeah, exactly. And it's not often, this is not a blanket statement, but often the thing that attracted you to this other work is neither an idea nor an expression of an idea. It's a nothing from a legal standpoint. It's not protectable.
Right.
Now you mentioned expression. I think the three of us need to explain to your listeners,
sure,
what that's referring to.
I will leave it to the experts, but yes, ideas and expressions.
John?
Wow. I just got hit in the ankle with a softball. Of course, the problem with let me back up in terms of the T-shirt. I remember years ago, every Saturday I would hang out with a group of clients and would-be clients that were comedians. And we'd all get together at a cigar shop and tell stories and war stories from the week before. And if someone would say something particularly funny and original, someone else would yell out, "Copyright!" And we'd all get a laugh about that. And of course, that's off base for a couple of reasons. One, it's while it's expressive in terms of the Copyright Act, it's not expression. It's not been memorialized in a permanent form. And even if one of us were to quickly, clandestinely whip out a notebook, in those days and age, a notebook was actually something you scribbled on with a pen because it was paper. But even with an electronic device, if you pulled out your cursor and memorialized it and hit save or send, with that pithy original statement, it really is just too little to raise to a level of copyright protection. Now, in the broader sense, copyright protects your original work. And original means original to you. It's something that you actually wrote. You didn't copy it from somewhere else. You may have gotten the idea somewhere else, but the expression is actually yours, and you're putting it down in a permanent form. Right. And that's one of the necessary conditions of intellectual property protection, is that permanent formness.
And one of the other things people constantly confuse, lay people constantly confuse, is patents and copyrights. So what this guy who sued Steven Spielberg, because he invented the idea of a love story and a disaster film, he thought that was like a patent. If I came up with it and I was the first person who did it, which he naively thought, he was no great historian, then I own this thing. And of course, as you two lawyers know, these are quite different concepts and quite different legal.
Yeah, it sounds like somebody oversubscribed to the search engine. He must have figured I invented it, Googled invent, and came up with a bunch of hits for patent websites, because they are very much different concepts. Patents really are about the idea. It is about the invention. Whereas copyright is not about the idea. The code expressly excludes ideas. It's all about your tangible work product on the page, whatever screen that page may be.
See, I'm sympathetic to people on this, because copyrights, trademarks, and patents don't always have the best siloing, even from judicial opinions. So I understand how you can get confused on this score, but yes, they are very different, no question.
I want to throw a monkey wrench in here.
Sure.
I taught a course in which I dealt, one of the major subjects was copyright. And my team teachers for a period of time were the former head of business affairs at Paramount, who had 40 lawyers working for him, and the guy who was the lead lawyer in the Buchwald case, which I assume we'll eventually get to. And we had a question or a hypothetical that we would toss out to the students, which was this. You're in a restaurant, and this is Los Angeles, so the people at the table next to you are other screenwriters, and they're talking about this story about some convoluted plot in which somebody's trying to discover something that's very powerful or will make you rich. Can you use what you hear from these strangers in the other table? You sit there as you're supposedly listening to your friends at your table, and your ear catches this, and you perk up and you say, gee, that's a great story. Well, what do? You go over to the table and then introduce yourself to the stranger and say, may I use your idea? Well, I've never heard of that.
Of course not, because it's rude to approach celebrities in Los Angeles.
Exactly.
You would never do that.
These are not celebrities. These are just working stiffs. But so the usual response that we would get from students is, no, that's illegal. And they're surprised to hear, especially my two lawyer partners in this class, say, no, it's not, because the mistake in this situation, and this is something I would urge on your listeners too, if they ever come up with a great story, idea, or plot, the mistake was on the part of the writers at the next table,
Sure.
speaking in a loud voice, giving their story away to anybody who happened to be listening.
Although I would add,
Yeah.
you don't want to go ask permission.
Yeah.
Well,
Yes,
exactly.
We should get to that, because that's another misunderstanding that I constantly faced.
Well, sure. I mean, when we're talking about the elements of an infringement claim period, one of the things they're going to want to try to show, as you write about in your book, is that you had access and that you knew about the thing that they're going to accuse you of copying, and certainly going and asking for permission makes that a lot easier.
Yep. Yep.
But it's interesting, in the Ninth Circuit in the last 40 years, these cases just don't turn on access. Although I totally agree with you, you never want to give away access. You shouldn't ask permission when you don't need it.
Sure.
Unless there's a valid business reason, and I think biopics are the classic example. Most folks, as a matter of industry practice, think they need a life rights agreement, when in fact what they really need is the cooperation of the estate and access to perhaps private letters and photos. But to do a picture based on the facts of someone's life, that life rights agreement is not something that the copyright code or contract law demand.
Right.
However, students will then ask me, well, then why do the studios pay for the life rights so often? And John, what's the answer to that?
Well, it's an insurance policy, really. You're getting that waiver and consent in it, and preempting the folks that would likely have a viable legal challenge to your using that information. You've just made them part of the team.
One of the things that creative people, especially writers, tend not to be aware of, or if they've heard the statistic I'm about to speak, don't put it together with what we're talking about now. On average, for a typical American film, the cost, all of the cost of a script, even if as often happens, even if there are 2, 3, up to 10 different writers that are brought in at different phases along the way, the average total cost of the final script is about 3 to 4% of the budget of the film. Therefore, well, that's the usual reaction I get. And John and I are, we're not making that much on this book. So this is the plight of all writers everywhere. Now, if a studio today is spending, let's take a low budget film, $1 million film. If they're spending 3% on the script and it costs them another 1% to buy the life rights or to buy a biography that somebody has published, it's not really a big deal in the terms of the total cost of production. So they do it, as John said, for insurance. So they don't know what relative or heir or cousin or friend might come out of the woodwork and make some kind of claim against you because there was a recent case, John, who was it recently who sued because it was a biopic where they were, Olivia de Havilland, where they were depicted in a bad light.
Well, yeah, actually, I wanted to backtrack for just a moment, and
Sure.
I think there are many that would say that for the few minutes that de Havilland's depiction was on screen, it was actually a fairly favorable depiction, at least in terms of what you typically see in the litigation. But let me backtrack about the use of life rights agreements. The reason a spec screenwriter might want to get a life rights agreement is very different from why the studio would get one, or why the distributor would insist on one, or the insurance company would insist on one. Certainly the studio and the insurance company, the production company, they are doing it as a belt and suspenders against litigation. It's to make sure that there is to minimize risk. And that's all about the business and the economics of the business. As a screenwriter, you're going to be selling the project upstream. And it's going to be the insurance company and the production company that make the decision and decide that they're going to have the project underwritten with a life rights agreement. Why would you worry about that? You're not going to whip out your checkbook and do the underwriting for them. But the reason you would worry about that, as I kind of alluded to a few moments ago, is it allows you to get better access from the subject or the subject's estate. It makes them part of the team. It gives you a backstage pass to private material you wouldn't otherwise have had. Because if you're just having to rely on the facts that are publicly available in the world, you may not have as deep a project or as good an angle as someone who does have that backdoor pass.
Sure,
so
absolutely.
It's really a question of if you're really wedded to this person and the topic, and you've got a unique and interesting take, and you should be able to generate that same interest on the take with the person or with the estate and get that backdoor pass. It makes for a stronger project.
Yeah, I find that interesting. Obviously, I'm not involved in the industry, and you sometimes see biographical pictures come out, one that's official, one that's unofficial, and I will tell you, on the official side, certainly one of the things that's attractive is that backdoor pass. Hey, they got access to those letters that nobody else has access to, that kind of thing. I will also say one of the things that's attractive from an unofficial standpoint is I think at least kind of in the back of your head is you do wonder, just as a kind of audience member, is the official side, the side that actually has to go talk to the family, are they maybe gilding the lily a little bit, maybe making the whole biography a little bit more positive than the unofficial can get away with?
It's an interesting tension. It's like, if it's official, is it candy coated? And if it's unofficial, is this really the dirt? And I think there is that kind of knee-jerk feeling to that. I know I'm susceptible to that.
Sure.
But really, in seeing how writers have developed projects over the years, I'm firmly convinced that although you don't see as much an official biography anymore, because I think it has that stigma that this is heavily censored and candy-coated, but the writers that are working with the imprimatur of the estates that are under contract and get that backstage pass, it makes for a much more interesting much more interesting topic.
Yeah. I think that's where I come out as well.
One of the things, as we've said, we make a major point of in the book, the world is full of possible stories for you to adapt into, in this case, screenplays or novels or whatever. And they're available without paying anything. But in the case of a biopic, if you go pitch a film or a television series or whatever on somebody where you don't have the cooperation of the person or the estate or the family or whatever, you have to always understand that, let's say, I discover there was somebody in the in Iraq during the first Iraq War who really did something sensational that would make a great movie. And so I go to a producer or a studio or a network and say, I got this great story. Did you know that during the Iraq War, blah, blah, blah? They can say, well, that's not really very interesting. And they can turn around and go to this person you're basing the story on or their family or whatever and get the life rights.
Sure.
You can be left fuming that they stole here we are again, they stole your idea. I had the idea for making a film on this unknown person, and I told you this idea, and you told me you didn't want to make the film, and then you did. So you stole my stuff. That's not a violation of copyright.
Sure.
John, what is it?
Well, no, it's not a violation of copyright, and interestingly, it's the case that the pellet dropped on me back in 2007 when I approached you about this book, as I had just seen a piece in the Los Angeles Times by our colleague Jay Fernandez talking about a lawsuit in the Ninth Circuit that had been dismissed over the film We Are Marshall. And there had been a documentary on the topic a few years before that, and the documentary filmmakers had been in discussions with the studio. I think it was Warner Brothers. They never reached contract, and the project did not go forward, or at least it didn't go forward with the documentary makers. And a few years later, the historical drama biopic was in broad release. So it really introduces the question of, when you're out there pitching a factual biographical story, what are you relying on for protection? And as I think we mention in the book, and as I've always told clients, your best protection first and foremost is dealing with reputable people, knowing who you're dealing with, knowing who you're dealing through. Because ultimately, it really does all come down to relationship and integrity. If you're on a lot, go ahead.
No, I want to hear the end of this, because I was going to actually segue into something else, because I really like that concept of trust, and it's one of the things I wanted to hit while we talked.
Yeah, well, let me get you there fast. And ultimately, the courts have yet to acknowledge a finder's fee type concept when you're bringing in a true story that they didn't know about or weren't focused on, and you've just brought it to their focus. And it's problematic. And I think that does come into the implied in fact contract. That should be part of the deal, that if you're there on the lot and you're talking with development executives and you bring to their attention a project that would otherwise be free for the taking but is not on the tracking boards and was not in their development cycle, that you should be in the, not only considered to be part of the chain of development, but also the chain of compensation.
Yeah.
But we've yet to see that case. And that's what really, as a practicing lawyer and a new screenwriter back in 2007, really really caught my attention is that this case, I thought, should have been decided in favor of the documentary filmmakers because they'd done the dance, they'd done the rounds, they had an underlying piece of property already filmed and in distribution on the same topic. It just seemed to cry out for an implied in fact contract ruling. But again, it's knowing who you're dealing with. It's being a repeat player in the industry and developing a reputation of trust and integrity. And it cuts both ways, both for the sellers and the purchasers.
Yeah, absolutely. And that's really what I wanted to talk about. I have a couple of things that I wanted to mention because I got this book, and I love movies. I love the visual arts. You can see on the Hoeg Law channel that we do a whole host of things outside of law, including postmortems on popular films and talking about narrative structure and things like that. But not everybody does. And so it was interesting to me that it says legal essentials for screenwriters, but also and creative artists as part of your subtitling for your book. And so I was reading this, and I was looking at a number of different areas and saying, I really like how a lot of different parts of your book, different chapters, different places, really are generally applicable to just people that are dealing certainly in screenwriting, certainly in creative endeavors, but also in terms of just dealing with business and contracts and the kinds of things we talk about on this channel. One of those things that jumped out to me was this trust concept. I think you get it absolutely right to say, in this particular case, you're talking in your book about the unconscionability of the non-disclosures that go along with talking about specs or pitches and things of that nature. And one of the things you say is, well, they're probably actually enforceable, although nobody's ever gone all the way up to the top court for this. But at the end of the day, you're really deciding on whether or not you trust the other person. I tell my clients, the words on the page can only do so much if you don't trust the other guy. What are some things that you look for when you're saying to, whether it's a client or just a student or someone else that you're advising, they're not sure if they're going to get into this? How do you know who to trust on the other side of one of these equations?
Well, first and foremost, if you're dealing through your agent, you want to know what level of clout your agent has within the agency.
Okay, sure.
Are they brand new, or are they someone who has a track record and a track record for integrity? If you're dealing on your own, certainly access becomes more problematic, and unfortunately, you may be trading a lot of emails. You may be dealing online and not having face-to-face dealings. It's a double-edged sword. Not only are you not having that direct access, but there's a tremendous amount of information out there to identify who you're dealing with, to find out whether they have a track record, and whether it's someone that you feel comfortable signing that inevitable consent form that goes with submitting a spec that basically is a hold harmless if you think somewhere down the road that they've made a film that's an awful lot like yours. And it can be very disconcerting. You want to get in the game. You have a contact that seems ready, willing, and able to enter in discussions with you. But really, how legitimate are they? You need to do your due diligence and know that.
Right, and you've got horror stories all around your brain at that point.
Yeah, it's difficult. It's difficult.
In many of the cases I've been involved with, when it's the defendant's lawyers who are trying to hire me, they'll tell me, my client never heard of this writer, never saw this script. It's just insane to accuse him of doing this. Mm-hmm. I can't tell you how many times. I regard this as virtually part of the spiel every defense attorney makes. It's just like, what percentage of people who've committed a crime insist they're innocent?
Sure.
And my response is, look, everybody knows, especially everybody who goes to movies, that everybody in Hollywood lies, cheats, and steals to get whatever it is they want. And then if you catch them red-handed, they'll lie and cheat again to avoid responsibility. So although the claim is always made, that we didn't see it, we never heard of this guy, and so on. People just don't believe you if you are a big producer, director, studio, or whatever, which is one reason, as John was saying earlier, the question of access, although it's an important part of the law, it's in practice, essentially everybody just accepts that nobody's going to believe the defendant who says I never saw the work. So it's seen from the other side of the fence. I mean, I know of many really fine human beings. Whoops, that's not a phrase I wanted to use. It reminds me of somebody. I know of many really great people who swear up and down they never saw the work they're accused of, quote, stealing.
Sure.
And they're left dangling in the wind for literally years. They're accused of being a thief. It always gets into the press. And I'm thinking of one Academy Award-winning screenwriter who in the very next year was sued for this, and the headlines were so-and-so accused of stealing this stuff. And of course, it takes a long time to get through the courts. And by that time, anyway, people forget. They remember that you were accused of stealing. They don't remember, or perhaps never even read, that you were acquitted. So from the other side, it's really a difficult situation. John, we were talking a bit back about something which I think is the point at which to talk about Desney versus Wilder, idea theft.
Sure.
That's your favorite
Well,
case.
you know, idea theft is, well, let me back up. There is federal copyright law, which preempts all state efforts at intellectual property protection for authorship. If you're a writer, your protection is under federal statute. And it's the copyright statute, Title 17 of the United States Code. But in every case that gets filed, there tends to be an alternative theory of recovery, and that's contractual. And contracts are a function of state law and varies very much from state to state. What's acknowledged as implied in fact contract. In California, in New York, were the very first states to find an implied in contract theory behind pitch meeting.
Sure. And when you say implied in fact theory of a pitch meeting, you mean that somebody comes up, they pitch an idea, and there's some implied obligation of the studio to not steal it at that point in time.
Well, exactly right. It's that in a lot of ways, the courts are starting to look at pitching as a service in and of itself. That you're not there to talk, you're there performing a service when you show up on the lot and meet with development executives. And the compensation for that service, if in fact it's accepted, which is the idea is under consideration and is put into the stream of development, is that you wouldn't be there, you wouldn't be performing that service if you didn't expect compensation if ultimately your project goes forward and reaches the screen. No one ever goes in and starts a pitch meeting by putting a contract on the table that says that. And it's bad form to go into a pitch meeting and even suggest that orally. You don't want to be there to talk about the legalities of this is my ID and it's protected. I want you to understand we're talking under a non-disclosure agreement. That sets the tonality all wrong in the room. So as a practical matter, the writers who need this the most are in an inferior position to put that on the table. And I think the courts realize that. And that's why the contract can be implicit. It's implicit from the scenario. It's implicit from the fact that you're on the lot. Now, as Howard mentioned earlier, if you're not on the lot, if you're talking to your personal trainer, you're talking to your bartender, you're talking to your friends at a cigar shop, places that are informal, that you're talking just to be talking. You're not trying to sell your idea. You want to hear what your idea sounds like, and you may be getting input on it, but you're just talking. Those aren't a contractual commercial context, and those are very dangerous contexts.
Sure.
That's where you risk giving it away for free. And we all fall into that. We test our ideas out loud. We do it all the time. It's part of the creative process. But I would suggest you need to do that with your kitchen cabinet, your core folks that you trust. This is your writers group. This is your collaborator. This is not, well, this may not even be your mother if she's talking to the neighbors. You really want to know who's in the room and what are the leaks of the room when you're in the development process on a project. So as much as I think we all benefit from talking through projects out loud, I know I do, it's important to know who you're talking with. And ultimately, when you get into the commercial stream, you want that talking to be face-to-face on a studio lot.
Well, because Howard's sending his students out to sit next to you in restaurants and steal your ideas.
Right.
Right, yeah. There you go.
Right. Tom is crawling with them. Well, there was a famous film by the great director Billy Wilder, came out in 1951, called Ace in the Hole. It had a different title some places. I can't remember what it is. But John, I'm waiting for you to pick that up. So the film came out. A guy named
it's a situation that really talks about the beauty and the charm and the simplicity of the studio system back in those days. A guy cold calls the studio. He calls Billy Wilder's office at Paramount and wants to talk with Billy Wilder, and he gets Billy's secretary.
I love this story. I really like this.
Yeah, and the secretary is like, he's not available right now. Perhaps there's something I can help you with. And he says, well, there is. It's great. I've got this idea, and Mr. Wilder's going to love it. I want to pitch it to him. And she goes, well, that's not the way it works. And boy, truer words were never spoken, because it doesn't work this way anymore, and it's probably didn't work that well then. But she says, why don't you pitch me the idea? So he does. He's a guy who's trapped in the hole. It's a real story. It's a true story. It's unbelievable. Trapped in the hole. He was a mining accident. They can't get him out. It rivets the attention of the nation. And
this part was all true, by the way. This was in newspapers across the country.
And that goes back to my finder's fee concept of you've got a true story that has now fallen out of the popular culture. No one really knows about it anymore, and you bring it in and you pitch it. You are doing a service. You absolutely are. You've become the search engine bringing forward a high concept idea to a producer that otherwise would not have that in their attention and on their landscape. But one thing leads to another. He wants to, he says, well, I've got a 60-page treatment. I'll send it in for Mr. Wilder. She's like, oh, no, he'll never read that. Some things haven't changed. And she says, well, how about if I tighten it up and send a shorter version? She says, well, why don't you send it to me? So he goes back, shortens the treatment, calls her up on the phone. Did you get the treatment? She did. I did. Let me ask you some questions about it. So they have this back and forth in a second call. And at this point, the writer starts to introduce the elephant in the corner. He says, well, if Billy Wilder uses this, I'm going to get paid, right? I mean, the whole reason I'm doing this is I want to get paid. And she assuages his anxiety. Of course, if Mr. Wilder uses that's how we operate. If he uses your idea and makes a film, most certainly you'll get paid. And Paramount does, and he doesn't get paid. And that's one of the many reasons none of us ever get to talk to the Billy Wilders of the world anymore.
Yeah. Well, I want to correct that, John. It's the fact that he sued, and there was a lawsuit that went to trial, and so it cost the studio a lot of money, but also a lot of embarrassment, because the guy is saying, you guys stole my stuff. And of course, as I said earlier, everybody believes that.
Yeah.
And so the studios, it took them a period of time to make this the industry policy. All of the studios and today the networks, if you submit something, I'm thinking of a script now, without an agent or anybody knowing it's coming, a blind submission where you stick it in an envelope and send, or even worse, send it by email, the studio will immediately respond with a formulaic response that says, we're sorry, we don't even look at unsolicited material, and so this hasn't been open. You sent us an email. We haven't read the email. We just read the first line of so we had your address to respond, but we didn't read the rest of the email, and don't ever talk to us again.
Sure.
Because, I mean, I've really enjoyed the supplemental income I've had being an expert witness in cases where it's usually some new person, some new young person, often from UCLA or that other place across town you mentioned.
Indeed.
It's some young person who didn't receive proper training, who opened the damn thing up.
Mm-hmm.
And just breaking the seal, now they can prove access. So a lot of potential creativity just goes nowhere because you can't get anybody to read it unless you have an agent or a manager. And how do you get an agent or manager? John and I are constantly asked. The answer is, despite what we may try to say by being courteous, the answer really boils down to God only knows. There is no prescription.
The way to get an agent is to sell a project. Once the project's sold, the agent will arrive. I think.
Wait, I caught a problem here.
Yeah, yes.
You did you?
There seems to be a bit of a catch-22 there.
Absolutely.
Yes, indeed.
Yeah.
I want to go back for a moment, though.
Sure, absolutely.
Rick, that you were pointing out that got us into this line of discussion, and that's about the integrity issue and the similarities that these issues have for all idea entrepreneurs. Bill Gates, if you're listening, I think this is a great airport read. I think you ought to pick up creativity and copyright because the concept of having to take pitch meetings in this day and age cuts across all industries.
Yep.
If you're an idea entrepreneur, if you're in any of the creative fields, and in terms of creative fields, not surprisingly, the prima facie case for software infringement, for example, is the exact same as it is for screenplay infringement. It's the same federal statute. Although the technicalities are a bit different, it's the same test of access and substantial similarity. So it's having to take these concepts into meetings to try to generate interest with potential partners, potential investors, potential buyers. All of these beg the question of, who are you dancing with? Is this the right dance partner? Is this a trustworthy dance partner? And I think that cuts across a lot of lines. I happen to think that the stories are a lot sexier in a Hollywood context.
Oh, it's good. It's good wrapping, absolutely.
But really, the The idea of what you do when you're ready to start selling holds true in really across the board.
Well, absolutely. I mean, I cut my teeth doing venture capital, and I work with emerging companies on really both sides of that equation. And, they've got some magic tech, or they don't, but they have to go and they have to look for funding sources. And I am constantly asked the question, how much do I protect my secret sauce? And the answer is, we can ask for NDAs. We can do all sorts of things. Just like a pitch meeting, as you guys suggested, sometimes that's not the tone you want to set in the room. But at any level, unless you're going to sue them, and chances are if you're looking for financing from these folks, they've got more money than you, and they're going to have some lawyers if you try to sue them. You have to trust them when you have that conversation to begin with. And that comes through in your book, absolutely.
Yeah, and nothing sends the signal the wrong direction of, hey, it's great to be in the room and I don't really trust you, so let's talk about prophylactic steps of contracts.
Yes, I'd like a couple million and I don't trust you. It's always a good sign.
Right.
Rick, have you or your clients ever had a request from somebody who was pitching to you that you sign an NDA?
Yes, absolutely. So I've represented funding sources as well, and a lot of times, you get somebody, maybe they have a good idea, maybe they don't, but maybe they're not necessarily a serial entrepreneur or that sophisticated in this stuff, and they're really, really worried about it. They've read the newspaper articles, they've read the books, whatever. They've seen the social network, and they're worried about being Facebooked. And so they say, we got to get in front of these guys. Rick, I'm not going to walk up to this venture financing firm or whoever I'm going to talk to without an NDA that's ironclad. And I'm like, well, they're not going to sign it. They're going to laugh you out of the room. It depends on who you're talking to, of course. Yeah. But absolutely.
On the other hand, have you or your clients ever required somebody who's come to talk to you to sign an NDA?
Yes. I mean, it's really dependent on the client's personality, and like so many things when we're talking about contracts, leverage. I mean, how magic is your magic? And if you've got a lot of people and you're doing some kind of stalking horse bidding, then you can ask for a lot of things from a lot of folks.
Yeah. Well, in the film television industry, before anybody will talk to you if you're a stranger, or if you come in without an agent or manager who they regard as being a real pro who knows what he or she is doing, they will ask you to sign a release form. Mm-hmm. And this release form, John, you're the lawyer, so why don't you tell us? What's in the release form?
Yeah, I think we touched on that a little bit before. Is the release form is absolutely one-sided. It's very much in favor of the buyer, of the studio, of the production company, and it, in no uncertain terms, says that you're not going to sue them. You're not going to sue them if they use an idea that's like yours. You won't sue them if you use an idea that's substantially similar. That you acknowledge and agree that even though you don't know what their slate of material is, they may very well already have something in parallel development that's exactly like your idea. About the only thing you don't have to waive is your right to the glass of Perrier, because nothing else in that room is actionable. You've got a right to one glass of water.
That was on the back of your parking pass in case it kills you.
Right. Come on in, Mr. Geiger. We'd love to talk with you. What do you have for us today? Go ahead and pitch. Would you like a glass of water? Yes. That's the last leverage you have in that room.
Sure. And that's the case in all corners of the world. That's one of the reasons I really like a lot of what you have to say. I think you put it right. It's got a nice gloss with all of the television and film anecdotes. One of my favorite chapters in this book is chapter 7, The Confessions of an Expert Witness, which we've gotten a little bit of from Howard on this video and podcast. But one of the things I really liked about that chapter is that we try in virtual legality to kind of break things down in terms of items of news that you're looking at and that you're interested in and talk about the business and law. Howard and John, you do that for, I don't know how many, 14, 15 different movies and issues that some of which were very famous when they happened. Yeah. Do you have a favorite there? I know my favorite is the Amistad case, but do you have a favorite there that you really like, Howard?
I was going to answer until you got to like.
That you find interesting and useful.
Useful, yes, absolutely. the Buchwald case that I referred to earlier.
Sure.
The Amistad case was sort of more fun because of the way it turned out.
Yeah.
But the Buchwald case is, even though I'm trying to remember how old that is, 20, 30 years old.
Coming to America, 1988 was the film. Yeah.
Yeah, thank you.
Yeah, 1988. Yeah.
Oh, well, that's only 20 something. But that was the last big case in bold type that I was involved with. By big, I mean the amount of money at stake was big, in the millions, and it got enormous amount of press coverage, and it also had an effect that John and I have talked about this for years. I've put it, why are there so few copyright cases that go to trial in the film television industry today in comparison to in the 80s and 90s? And one of the answers we seem to agree on is the Buchwald case was a Pyrrhic victory, in which you win theoretically or technically, but the cost of winning makes the victory a very shallow, hollow one. Let me explain the case. Art Buchwald was a famous columnist for many years, carried in hundreds of newspapers across the country, and he partnered with a producer and signed a contract with Paramount, which said if anything they submit becomes a movie, they will be entitled to compensation. They didn't specify what it was, because that, of course, would be impossible. They submitted a half a page. They called it a treatment, but treatments are usually several pages. This was a half a page, and essentially it said this: Eddie Murphy, who was then the biggest star at Paramount and perhaps in the industry at the time, is an African prince, comes to the American ghetto. Well, this is the fish out of water kind of story that is the basis of virtually all successful comedies. The film Coming to America that subsequently came out, starring Eddie Murphy, who is an African prince who comes to, I think it was the Brooklyn ghetto, sure sounds a lot like the pitch from Buchwald. Well, they submitted it. The administration at Paramount says, well, thanks anyway. And then I forget how much longer afterwards it was, Eddie Murphy turns in a treatment film he'd like to be in which he would be an African prince who comes to America. They made the film. It was this gigantic success. And so they went back to Paramount. They were on the lot working with friends. And they said, hey, we got a contract that says you owe us something. And first of all, this is my speculation in the following paragraph. Paramount was really was trapped. Their most commercially successful star says he wrote this treatment. It was his idea. They weren't going to annoy their their star, and so they had to defend it and say no. This is what it obviously was like. Okay, end of editorial. It went to trial in a local court in Los Angeles because this is not a copyright case. This is what my partner was referring to earlier. It's a state court, and the issue is a contract. Well, after something like 2 years of litigation. The Superior Court judge found in favor of Art Buchwald and his producing partner and awarded them $800,000 plus, I'm not sure this figure is right, 200,000 or something in legal expenses.
Ooh.
I mentioned that I teamed up with these two lawyers. The key lawyer, Pierce O'Donnell, in this case told me, and this is public knowledge. He wrote a book called John. What is Pierce's book? And his firm spent $3 million in billable expenses. $1 million alone in Xerox costs.
Yep,
And,
lawyers.
Which to answer your question, Howard, let me interject. The book title, quite apropos, is Fatal Subtraction.
Thank you. Fatal Subtraction. Yeah,
It's a good title.
It works in so many ways in this context. Yeah.
Yep.
Well, a matter of months later, my now good friend Pierce O'Donnell decides he's going to open up a single person law firm. I didn't ask him, but I assume that the large law firm in Century City that he was affiliated with was not too happy winning, in quotes, a case that they'd spent $3 million on and now had a few $100,000 as judge awarded legal expenses. So You're a lawyer, Rick.
I am.
John's a lawyer. A client comes to you saying, these guys stole my stuff. And again, I would echo what John was saying a minute ago. All of this stuff applies to a great many fields, not Hollywood, not just movies. It almost goes without saying that a person who comes to a lawyer saying they stole my stuff is, number one, young. Number two, partly because of number one, is broke. They don't have any money. They don't know how to pay their rent. So what do they ask you to do in terms of the expenses of filing a case?
Oh, yeah, that's a contingency request. There's no question about that.
Yeah. And would you explain to your viewers what that is? Your listeners?
Oh, sure. Yeah, no, absolutely. The practice of law, I'm a transactional guy, so step one is I'd tell him I could find him a litigator. But in terms of billing, we generally bill by the hour, we bill flat fee, or one of the last options is we can bill contingency, which means for a litigator, you go and if you win the case, you get a portion of what you won. But it means that you're essentially what we might call seller financing the entire process until you get to that point.
Right.
And we actually address that in the book on
yes, you
assembling
do.
your legal team. Although I think the general mantra that Howard and I live by is avoid litigation at all costs. That Art Buchwald probably was not in it for the money, and those who go forward with lawsuits on copyright infringement in film oftentimes are doing it something for other than money, or not. The money isn't the main concern. It's about validation. There's something personal about it. And as a former trial attorney, because I'm a transaction guy myself now, but as a former trial attorney, I can tell you the most dangerous client is a client that's in it for something other than money, because it's very tough to graph that, to chart that. In the classic textbook on this, because everyone knows all truth is found in the film. If you go to film archives, it's the Bible of human nature. You look at the John Travolta piece, A Civil Action, which is a classic example of a toxic tort case. A righteous cause, being on the right side of a social issue, brings a law firm down because of the bone-crushing economics of civil litigation.
Yeah.
Now, I know right now there's a movement going on for what they call the CASE Act, the Copyright Alternative Small Claims Court, where through a tribunal in D.C., writers and other copyright holders would be able to bring claims in a small claims forum. I think the proposed ceiling in the Senate bill right now is $30,000. Now, that's a step in the right direction. It's certainly not a remedy for theft in the film industry, because that doesn't even get you to Writers Guild minimum for an aggrieved screenwriter.
Sure.
But I think it is in other contexts for small clip documentary filmmakers or for graphic artists, for photographers in particular. That's a really good proposal, because if nothing else, it gives you some teeth without having to go down and get an attorney and convince someone to take a case on contingency and file in federal district court, which is austere and formal and obscenely expensive. Instead, you can get the ball rolling, because the real action in these type of disputes is to get someone to the table to negotiate. Infringers oftentimes are not intentional infringers. They can be unintending infringers, and the economic realities will control. You get to have, in a post-filing world, the negotiations that you should have had before the lawsuit was filed. Now you've got their attention. And I think that makes a lot of sense in a lot of different contexts. It doesn't, unfortunately, for the big feature film lawsuits. I think ultimately, at the end of the day, Howard, I don't know if you mentioned this, I think Buchwald's legal fees were in the neighborhood of $3 million, and Paramount's were $4 million. And that's in late 1980s money. It's crazy now. I don't think you could take a copyright infringement screenwriting lawsuit cover to cover in federal court these days for under $1 million.
Yeah, I believe it.
So that's a contingency case. And if you're in the Ninth Circuit and you're a plaintiff's attorney that knows copyright infringement, you're going to be really hesitant to take that case, because you've seen what the Ninth Circuit does on summary judgment to aggrieved writers.
Absolutely.
It's a tough claim to push.
At the risk of totally disillusioning your listeners,
if they're this far into virtual legality, they might be disillusioned already.
or confirming what they already thought they knew, that everybody lies, cheats, and steals, etc. But that we talk about another aspect that we both share real concern about. At one point, I think we say our advice to you is, unless you'll live the rest of your regretting that you let these sons of bitches get away with it, and you have to, I think John's word was exercise this feeling. Unless you have that, our advice to you is, you consider suing, is don't, because even when you win, you lose. But we go on to say it's not just the money. It's, if you're a creative person and you get into a major lawsuit or even a minor lawsuit, you're going to spend often literally years gnashing your teeth as you're trying to fall asleep over those blankety blank. They're trying to rob me. They said they never saw it. I know perfectly well. And meanwhile, not only are you wearing the filings of your teeth down, you're not creating. You're so filled with anger and wrestling with the injustice of the world and that desire to get your revenge. I often have to say to young people who come to me seeking advice, look, this is not Perry Mason style drama lawsuits. I've never known in a copyright case of somebody suddenly at the very end of the trial standing up and saying, "Yes, I did it. I'm sorry. uh,
Wouldn't that be nice?
That's that's a television series.
Only in 1950s television. Yeah.
Exactly. Yes.
Well, in talking about litigation and the time that it takes you away from actually working on your art form, I'm reminded somewhat of the memoir by the one of my favorite novelists, John Irving, where he talks about his experience with the film Cider House Rules. And I think the comment he has in there is that if he had it to do all over again, he would question doing it, because in the amount of time that it takes to get a film off the ground, he probably could have written 5, 6, 7 more novels.
Right.
And by analogy, if you're embroiled in the narrative of litigation for 3 to 5 years, can you imagine what that does in terms of taking you out of the stream in your artistic career? It not only do you lose the time, but you've got the emotional drainage going on.
Absolutely.
One of the
I think my clients are never more unhappy than when they're in litigation. There's no question.
And a lot of what we've talked about so far is selling scripts and engaging in Hollywood in a more traditional business model. We also in the book talk about alternative business models that I think are becoming more and more mainstream. The great equalizer in a lot of ways was desktop publishing and desktop film editing and desktop production. And the other half of that equation now is digital distribution.
Sure.
For the first time, there is the opportunity in a very realistic, cost-effective way to self-produce your own material, or to assemble your own team in an outside Hollywood, outside studio sort of way, and put your own productions together. If you're not out there selling, you're not out there pitching, you're not out there otherwise broadcasting your work product in an effort to get it made, but instead you're making it, really the risk of infringement goes down considerably. And I think that's a lot more artistically fulfilling in a lot of ways. You can get more projects off the ground. You're more akin to a novelist in a John Irving sort of way.
Yeah, and I think we're seeing that a lot in my neck of the woods. We do Virtual Legality, talks a lot about software and video games, and there are a lot of auteur video game developers that are seeing the tools available to get out there. One of the very first videos we wound up doing was essentially on Rick. We want to make a fan game that's an homage to this other thing. What can we do and what can't we do? And I think for those people, this book, Creativity and Copyright, is, as well as Virtual Legality, is a kind of a great place to put your mind as to what intellectual property rights really mean and what you need to be worried about and what you don't.
Yeah.
Yes.
Yeah.
Yep.
So, gentlemen, I know our time is limited here. I would be remiss if I didn't use your expertise to talk about at least one major news item here. As you probably are aware, in the last couple days, Disney and Sony have gotten into a little tiff about Spider-Man, and I'm really interested in your thoughts on this. I did a Virtual Legality video on it the other day, but certainly Disney is now if they were an 800-pound gorilla before, I don't know how many pounds they are now after buying Fox. So, what are your thoughts on not only Disney and Sony fighting over Spider-Man, what Disney looks like now with all of Fox's intellectual property? What do aspiring screenwriters have to worry about? What do the other studios have to worry about in the entire landscape of Hollywood at this point?
Let me take it from the aspiring screenwriter standpoint first.
Absolutely.
Is that with Disney navigating its way into streaming services and now competing very robustly against Netflix and Apple and Amazon and Facebook, that's rising competition for distribution. And whenever there is a competition for content, that's good for writers. Content becomes scarce, the price goes up, the demand goes up. In the short term, at least, that's better than a writer's strike pending. That's a high demand scenario. The danger is that over time the supply starts to meet the demand. There is a risk, I think folks won't talk about it in polite circles, but it's the hushed discussion that the quality potentially goes down. If you can put it on a napkin and you can get into a streaming service, you can sell it on a pitch and then no one knows what to do with it. but there's a insatiable need for content, so they're going to film that napkin and get it out there. And over time, the supply and the quality of the supply catches up with demand, but that also causes the price to go down. So you get a renormalization of the market. I'm less concerned, and I think of that as kind of the microcosm view. That's an inter-industry view. And I think our colleague Peter Gruber would agree with this, that really the question becomes, what's the piece of the overall entertainment pie that film has and streaming services have? You're competing against sports teams. You're competing against an awful lot for the attention and time of the public. Are you growing the pie? Which in a lot of ways comes down to the Spider-Man dispute. There's what better advertisement is there than controversy?
That's true. And certainly it has all the makings of various parties leaking to various sources for reasons. And that's one of the things that I tried to get across, is that everybody's very quick to jump to Disney's bad, Sony's bad, Spider-Man's never going to happen anymore. And to me, to my eyes, obviously I'm not talking about $400 million deals every day, but it's one of those things where it looks like, it's a typical-ish hardball type contract negotiation, just writ large because of the players involved.
Absolutely.
So before I leave you, then I have to ask: is Spider-Man, are Disney and Sony, are these kids going to get back together or not?
Never count out the House of the Mouse.
Yeah, I tend to agree. Well, I want to thank you both for coming on Virtual Legality. I really love these conversations. I literally have probably 20 additional questions that I could have asked you, and I really do love hearing about all of this stuff: creativity and copyright, legal essentials for screenwriters and creative artists. I really do think is a fantastic read. If you made it to this point in the podcast or video, or you're a fan of the Hoeg Law YouTube channel or Virtual Legality in general, I think it's exactly the kind of material that you're going to get a kick out of, whether or not you're trying to sell a screenplay in Hollywood or not. And also, I'm informed that you, John, and you, Howard, are going to be meeting with folks next week, next Thursday, August 29th, at the Last Bookstore in Los Angeles. Is that right?
That's right. It probably will be our only Los Angeles appearance together, just the way scheduling has played out. So I'm hoping that our friends and folks that are interested in hearing more about the book and being able to sit down and have a glass of Pinot with us will come out.
Well, I tell you what, if I could justify the flight cost, or if I could expense it, I would be there and I would be monopolizing your time, because I think you guys have a lot of great stories, a lot of great insights. And again, I can't say enough how fun this was. Thank you for coming, and I hope we see you on Virtual Legality in 12 years for the next book.
Yeah, thank you.
Rick, our pleasure. Thank you so much.